Almost one more time, this meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. And it looks like we're all clear, so take it away, Glenn.
Okay, so like we talked about earlier, we have our live stream up on YouTube, and we have our I've got the document ready to go. We're going to talk about a petition for a writ of coram nobis today. There's you have to look in your local state and federal laws as far as, you know, whether this is applicable. It's an extraordinary writ, coram nobis, and what you're doing is you're bringing up some issues that weren't originally brought up in the original case. Now, you're getting them to review it. Okay, so what happened is a friend of mine in New Jersey, they held a show trial for him and convicted him, and then he didn't appeal within the proper time, and so his appeals were exhausted, and so we needed to reopen the case. And so that's why we brought the coram nobis, because then we can appeal that depending on what happens. But we have to, part of the coram nobis is it's an extraordinary writ, and so you have to bring up issues that weren't originally brought up in the original case. In this case, a lot of these issues were brought up, but not all of them. And so get them to reconsider. Anyways, I understand, and I haven't looked at it myself, but I understand under federal, you can do a coram nobis up to 5 years after a conviction. But the states vary depending on whether you can do it in the state or the federal. And you have to, again, you're bringing up issues that weren't originally brought up in the case. So I'm going to share my screen. So this is the coram nobis. This is, I've kind of sanitized it. So the arguments, so we're going to try and make it as big as possible so people can see it. What happened is we filed this petition for a writ of coram nobis about a year ago, and we didn't hear anything about it. And so the judge finally responded. They can take their time on responding to something like this. And so what they did is they denied it because of failure to set forth grounds as set forth in Rule 3.22-2. Well, the thing is full of all sorts of grounds, but anyway, so we're going to specify the grounds now. And so in New Jersey, you have to do in lieu of prerogative writs, okay? So as a special proceeding under New Jersey statutes that in lieu of prerogative writs. So the respondent in error requests the court to reconsider the judgment in this matter for the following facts that were not available in the court previously. And we're still working on this. This is actually something that he lined out. And so we're going to have to, there's this, he went and put this, these are the grounds that are actually taken from New Jersey codes. A petition for post-conviction relief is cognizable if based upon any of the following grounds: substantial denial in the conviction proceedings of defendant's rights under the Constitution of the United States or the constitutional laws of the state of New Jersey, lack of jurisdiction of the court to impose the judgment rendered upon the defendant's conviction, imposition of sentence in excess of or otherwise not in accordance with a sentence authorized by law if raised together with other grounds cognizable under paragraph A, B, or D of this rule, otherwise a claim alleging the imposition of a sentence. So you can actually bring up just it's a bad sentence in excess of or otherwise not in accordance with the sentence authorized by law. And then any ground heretofore available as a basis for collateral attack upon a conviction by habeas corpus or any other common law or statutory remedy. So that really opens it up right there, I'll tell you. Anyways, a claim for ineffective assistance of counsel based on trial counsel's failure to file a direct appeal of the judgment of conviction and sentence upon defendant's timely request. So if that's another reason. So the rest of this stuff, the stuff that's yellow, is the stuff that we're planning on using. So, and this is the grounds. So I've actually, and we're still working on this, but a lot of this stuff, the grounds we didn't have there before. Okay, we just had the petition. And if you read the petition, I mean, it gives you the grounds, but we're going to have to specify these are the grounds. Anyways, the grounds for this petition are denials of due process of law as required by the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. Article 6, Clause 2 of this Constitution for the United States of America as follows. Now, the reason we call it this Constitution for the United States of America is because that's what it says in the preamble. We, the people, do ordain and establish this Constitution for the United States of America. Okay. Denial of an Article 3 court is required by Article 3 of this Constitution for the United States of America. Denial of judicial proceedings according to the course of common law is required by 1 Stat 73 and 36 Stat 1087 Judicial Code, and the Northwest Ordinance, which defines the nature of federal jurisdiction and federal territory, Section 14, Article 2. The inhabitants of said territory shall always be entitled to the writ of habeas corpus and trial by jury and of judicial proceedings according to the course of the common law, which is a contract under Section 14. The following articles shall be considered as articles of compact between the original states and the people and the states in said territory, and shall forever remain unalterable, and reaffirmed under Article 6, Clause 1. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation, and protected by Article 4, Section 2, Clause 1 of this Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. So denial of trial by jury is required by Article 3, so that's the third one. Denial of trial by jury as required by Article 3, and trial by jury as required by Article 6 in amendment. Now, notice trial by jury here is capitalized, and here it's not. And I don't know how many of you know this, but there was actually, we're doing some videos on the organic law of the United States, okay? And the organic law of the United States, if you go to the Office of Law Revision Counsel, which is a U.S. Department of Justice website, it will tell you what the organic law of the United States is. And it's the Declaration of Independence, it's the Articles of Confederation, and it's the Northwest Ordinance, and it's the Constitution. It's all four of those documents are the organic law of the United States. And so I have a friend of mine, Nelson, who is, we basically have a discussion, and I've got some YouTube videos up about it. We're going to have more. He actually is the guy that puts on the event in New Jersey. He lives in New Jersey. They own a couple beach houses, and so he's pretty smart. He's brought some stuff to my attention that I use, quite frankly. And so they had a style committee, and I sent out an announcement too about the Northeast Private Information Share. Maybe I should just put it on the group here while I'm thinking about it. Yeah, maybe I'll do that.
Yeah, I remember after you just got back from your vacation, Nelson came to the mic with you that one night.
Yeah. So let me find the announcement, and here we go. Yeah, right here. I'll upload it to the page.
Why is there only why is there a 5-year time limit? If there was fraud involved or non-disclosure, shouldn't that be open?
There's other remedies you can do. Habeas corpus. There's other remedies you can do. There's always remedies. Some states, the 5-year time limit again is. That's probably not a very good source. I'm going to find another one. It's not all pasting in there. So,
I had thought of habeas as well, but what about challenge of jurisdiction?
well, they've already taken it and sold you into slavery. So that's a bit of it's like closing the barn door after the horses get out.
Jurisdiction can be challenged at any time.
That's true, but your appeals, you have to do it through an appeal. And your appeals are exhausted. You cannot bring any more appeals. So you have to do it. There's got to be another way that you can do it. You see what I'm saying?
I was unaware of that. I thought it stood on its own. Well, there was not an appealable matter. It was something that was, you can bring it up at any time. In other words, if I was sentenced to 30 years and 20 years into my sentence, I decided to challenge jurisdiction, I should be able to challenge jurisdiction. At least that's my comprehension.
You got to do it through an appeal. Sorry, I hate to break it up to you, but I mean, the only way you can do it is through an appeal. You can't just challenge. They just ignore it. You got to get them to answer it. They'll just ignore it. They'll pretend it's not there. There you go. That's the announcement for the Northeast Private Information Share, 12th and 13th of April, 19th and 20th of April, 26th and 27th of April, and the costs and everything. So for anybody that's interested. So let's get back to this. Let's see here. Yeah. So, yeah, you can file appeals. You can file stuff all day long into that case, but nobody's going to answer it. Okay. The prosecutor has to answer it, and he's not motivated to because he can sit there and just ignore it, and they do it all the time. I mean, right now, even when they bring in criminal action against you, what you have to do is file a challenge to jurisdiction and then go in there and bring it up to the judge and have an order for him to sign. Either that or be prepared to get the transcript and use it for appeal. And that's the only way. And if they don't answer it, and they don't answer shit all the time, I've had it happen all the time. And so there's nothing forcing them to answer it. Anyways, so denial of trial by jury is required by Article 3. Let's see if we're making sure we're looking at this. Yep, we are. Good. Denial of trial by jury is required by Article 3, and trial by jury is required by Article 6, an amendment to this Constitution for the United States of America, and by the causes and necessities for taking up arms, 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. And that's causes and necessities taking up arms, 1775. Denial of trial by jury as required by Article 5, an amendment. Article 7 in amendment, and Article 9 in amendment to this Constitution for the United States of America. Denial of a speedy trial is required by Article 5 in amendment to this Constitution for the United States of America. Deprivation of assistance of counsel under Article 6 of the Amendment to this Constitution for the United States of America, with the forced bar member counsel evidencing the Star Chamber status of the so-called court. The corrupt Star Chamber courts of England required defendants to have counsel. Star Chamber stood for swiftness and arbitrary power, which is a limitation on the common law. Eighth Amendment, excessive bail, cruel and unusual punishment. Failure to provide prove jurisdiction when challenged. So those are the ones.
Glenn.
Sorry,
Glenn, you were going to explain the significance of the capital T for trial by jury and the lowercase t for trial by jury.
Well, the founding fathers had a style committee. There was a group of people. You know, I don't know if anybody's ever been to the Independence Hall in Philadelphia. I went there to look at it, and the building itself is probably about the size of like a 12 or 1400 square foot house. Okay, it's not a very big building at all, and where they held the convention was a room that was not much bigger than many living rooms that people have in their house nowadays. And so think about it. They had how many people in this room? And they're debating about how to do this constitutional convention and all the rest of it. They had the doors bolted. Nobody could leave until it was at the end. And there was a committee that their sole purpose in life was to decide what had to be capitalized and what didn't. And so in Article 3, it's capitalized, but in the Sixth Amendment, it's not. And so I think that what they're talking about when it's not capitalized is common law. When it's capitalized, that's when it's subject to something else. And so I'm guessing, and so this is something that we still debate, but there was some reason. The reason the capitalization is absolutely critical, and there's a reason for it. And so we need to understand all of that. So we're actually having, like there's last Wednesday we had a video, we did a live stream. So you can go to my YouTube channel and you'll see the live stream that we talking about the actually we're in there, we're going through the Declaration of Independence, and we only went through a small part of it. We're gradually going through all of the organic law, okay? And so that's the organic law, that's the real law, okay? Everything else is civil law. The only organic law is in the first 4 founding documents. That's the organic law. We have to understand that. Anyways, so I would suggest, I got a live stream. Actually, I don't think I have it scheduled yet for Wednesday, but we're going to have another one on Wednesday. And so I would suggest it'll be 7 to 9 Central Time when we're doing it. So I'll schedule it here pretty quick. I need to do that anyways. We do a live stream on Tuesdays and Wednesdays, and then on Friday too. This one's on Friday. And so the Tuesday one is at our Tuesday meeting. And then the Tuesday we're going to be talking about the organic law again. I'm not sure if we'll be able to live stream that. It's a little bit difficult. The sound is difficult to, we'll see. We'll try and have that live streamed. But certainly it'll be Wednesday. Tuesday is from 11 to about 3. Thereabouts. It kind of moves around when we have those Tuesday meetings. But we'll be talking about the organic law, and we're trying to get through all of the organic law, which is the Declaration of Independence. Why, what some of that stuff is. One of the things that is there's some pretty big words in the Declaration of Independence, and we were talking about that today. You got to know the definition of those words, or you got to understand what they're talking about in the Declaration of Independence. And they're talking about war crimes. Anyways, yeah, perfidy. There's a word called perfidy that's in there, which is deceptive. That's actually a war crime. And so, that's again, you got to understand that stuff and be able to explain it and articulate it, and that creates, excuse me, that all of that stuff is part of the law.
I would say that that's what we're dealing with right now with these administrative courts, that they're guilty of perfidy, barratry, and graft.
Yep, you're right. So denial. Oh, I went through all this. Yep. So a superior court of general jurisdiction. This stuff, all of this stuff was already there. Okay, we maybe added a little bit, but mostly it was already there. A superior court of general jurisdiction becomes an inferior court of limited jurisdiction when operating under an act of the legislature and derogation of common law. And this is American Jurisprudence 2D, Courts, Section 103. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. And that's Corpus Juris Secundum, Section 2. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. And that's Book 20, American Jurisprudence 2D, Court, Section 103. It's familiar law that when a special statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. An inferior court of limited jurisdiction acting under an act of the legislature is conducting an administrative proceeding for the executive branch. The word administrative is synonymous with the word executive. The word administrative connotes of or pertains to administration, especially management, as by managing or conducting or superintending the execution, application, or conduct of persons or things. Thus, administrative acts are those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body. In fact, it is common to use the two words in tandem. So this is a legislative act, okay? When acting to enforce a statute and subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer, executive branch, and not in a judicial capacity. Courts administrating and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It is the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for an agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. A judge ceases to sit as a judicial officer because the governing principles of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgments for that of the agency. Only a court operating under Article 3 of this Constitution for the United States of America can render judgments involving deprivations of life, liberty, or property. Justice Thomas concurring, constitutionally conforming agency adjudication. Cases involving deprivations or transfers of life, liberty, or property constitute a core of cases that must be resolved by Article 3 courts, not executive administrator dressed up as courts. And that's Axon Enterprises versus FTC 2023. And that's Justice Thomas.
That's new.
Yes, it is. Where a controversy is of such a character as to require the exercise of the judicial power defined by Article 3, jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or of course in an executive officer or administrative or executive board, since they are incapable of receiving it. Williams versus United States, 1933, U.S. Supreme Court. And part of your court's conviction was an order of commitment. The plaintiffs failed to have standing required to bring this matter into an inferior court of limited jurisdiction / executive agency. I think I'll just add something in there.
What? Not a setup for a nasty gram.
Working for the legislature because it fails to be an Article 3 court. As a general principle, standing is invoked. The judicial process requires actual justiciable controversy as to which the complainant has a real interest in the ultimate adjudication because he or she has either suffered or is about to suffer an injury. Without standing, there is no actual or justiciable controversy, and courts will not entertain such cases. Typically, the standing inquiry requires careful judicial examination of a complaint's allegations to ascertain whether the particular plaintiff is entitled to an adjudication of the particular claims asserted. Whether one has standing in a particular case generally revolved around the question whether that person has rights that may suffer some injury, actual or threatened. Failure of this court to be an Article 3 court is a denial of due process of law because it fails to be a judicial proceeding. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Ward versus Village of Monroe, U.S. Supreme Court. And the judge was in bad behavior and failed to be an Article 3 judge. The judges both of the Supreme and Inferior Court shall hold their offices during good behavior. Article 3, Clause 1. Officer who acts in violation of the Constitution ceases to represent the government. No corporation, State of New Jersey, Inc., County of Cape May, Inc., City of Ocean City, Inc., has standing to say anything to any man. Standing comes before any jurisdictional issues, and failure to provide standing, to prove standing, is a denial of due process of law. And this is Rundle versus Delaware and Raritan Canal Company, U.S. Supreme Court, 1852. My opinion is, and has long been, that the mayor and aldermen of a city corporation or the president and directors of a bank or the president and directors of a railroad company or other similar corporations are the true parties that sue and are sued as representatives and trustees of the constantly changing stockholders. A corporation, therefore, being not a natural person but a mere creature of the mind, invisible and intangible, cannot be a citizen of a state or of the United States and cannot fall within the terms of the power of the above-mentioned article, and can therefore neither plead nor be impleaded in the courts of the United States. That's obviously before the 14th Amendment. The 14th Amendment made it so they could. But the bottom line is they still have to have standing. The Forest Bar Member Council failed to be a council of choice as required by Article 6, an amendment to this Constitution for the United States of America. So what they're doing in this, with this friend of mine in New Jersey, is they're assaulting them with a minor estate, is what they're doing, because that's a corporation. The Forest Bar Member Council failed to be council of choice as required by Article 6, an amendment to this Constitution for the United States of America. In all criminal prosecutions, the accused shall enjoy the right of a speedy and public trial by an impartial jury of the state. That's the 6th Amendment. Let me go back here. I remember it said one of the grievances, denial of a speedy trial as it's actually Article 6 in amendment.
Another way of expressing Exxon versus FTC would be to say deprivation of core private rights. And that's from Thomas in Exxon.
Well, we're using the text out of the case.
Well, he actually uses the term core private rights in there, talking about these being administrative courts.
Where does he say that?
I'd have to look it up. It's in his commentary afterwards, his opine.
Okay, well, all I've got here is this, and that's what this says. But that's interesting.
I'll see if I can pull it for you and send it to you in email.
Yeah, okay, yeah, that'd be good. Thank you. Okay, so let's go back. We were here. Okay, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, and to be confronted with the witnesses against him, and to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. And that's Article 6 of the Amendment, because the respondent in error's choice of assistance of counsel was Charles Danielson, who fails to be a bar member, and the forced bar member assigned, counsel of the court, Elton M. Anglada, is further evidence of the nature of the proceeding being the executive branch Star Chamber in derogation of common law. The Star Chamber courts of England required defendants to have counsel. Star Chamber stood for swiftness and arbitrary power. It was a limitation on the common law, evidencing the denial of the respondent in error to his right to challenge jurisdiction. So they did that on purpose so he couldn't challenge jurisdiction, which is more denials of due process of law. See, impropriety persona and one's own proper person is a rule in pleading that pleas to the jurisdiction of the court must be pled in propriety persona, because if pleaded by attorney, they admit jurisdiction as an attorney is an officer of the court, and he's presumed to plead after having obtained leave, which admits the jurisdiction. And so evidencing with their forced jurisdiction. Which are more denials of due process of law. The respondent in error is entitled to trial by jury as required by Article 6 of the Amendment, which was demanded by the respondent in error himself, as well as the respondent in error's choice of assistance, Charles Danielson. And the trial by jury fails to be a jury trial, because a trial by jury is when the jury conducts the trial. And the War of Independence was fought over the denial of trial by jury. And this is the cause and necessities of taking up arms again. We already went through this. But instead, the respondent in error was provided a bench trial by a single jurist/judge, and trier of fact alone, which is another denial of due process of law. Due process of law is part of common law, and this court is operating in derogation of common law. And here's a bunch of court cases talk about common law. And I don't know if you want to go through all these. There's a bunch of them here, all of which is a denial of due process of law. So we got to reopen this case is the issue, and we're going to try and use this to reopen the case and appeal it.
What about a trial de novo?
Sorry?
Trial de novo?
You know, that's a trial by judge. That's a fake court. That's okay. Administrative. Whenever it's by judge, it's administrative.
They're all administrative right now.
Right, I know. Which means I go back here.
So we can't deny that good rulings are coming out, though. That case 2023.
Sorry?
Like, good rulings are being handed out. Like, they're not sitting very often. So
Well, if there's a good ruling, it's not by the regular courts. The lower courts, you'll never, ever, I've never seen any justice come out of the lower courts, okay? You have to set it up for the appeal. And that's the only way you'll ever get it. They're kangaroo courts. There's no justice that happens in them. What you have to do, and that's what they've dismissed my case. And actually, I've decided what I'm going to do with my case, too. I'm going to file a notice of contempt. I'm sure they're going to love that. Matter of fact, I'm debating about whether I want to just mail it to them or not. So if I wanted to really be flagrant, I might take it down there and file it with the clerk myself. But I got to do it. I got to file a notice of appeal. And so I'm debating about whether I want to take the notice of contempt with me or just mail it in. I think I'm just going to probably mail it in. Anyways, so.
Have you referenced the recent Chevron case in here?
I don't think we have. I think we have to. We need to look into it. We have to keep it below a certain number of pages, if I remember right. But so that means we got to keep it short. But
well, anyways, Chevron is very recent, and they're saying that these administrative courts are unconstitutional.
Yes, I agree. Well, that's obvious. And so we're bringing it up. But they're pretending that they're a real court. And so, you got to bring it up. And so that's what the purpose of this quorum nobis is. And it's the same judge. It's going back to the same judge. And so that's what a quorum nobis does, is it goes back to the same judge. And
they're pretending that the minor estate is a real thing.
I know. So what happened is it's going back to the same judge, and we're just trying to get the case reopened so that we can appeal it. And so far the judge has denied it because we didn't provide the grounds. So we're gonna file it again here real quick as possible with the grounds, and hopefully we'll get something here pretty quick so we can appeal it, because it was a complete denial of due process. Denials of due process.
Excuse me. Can I ask a question real quickly? What exactly was he afflicted with code-wise?
It was a municipal court action. Okay, they charged him with a felony, and then they dropped the charges and just gave him time served. Okay, it's a long story. Okay, and it really doesn't matter. Okay, we're not talking about what he was charged with. We're talking about the quorum nobis. Okay, and so if you want to learn about, you go and look it up in the New Jersey codes. We're not talking about what he got afflicted with. We're talking about the quorum nobis. Denials of due process of law deprives the plaintiff's inferior court of limited jurisdiction, executive agency of subject matter jurisdiction. Not every action by any judge is an exercise of judicial function. It's not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void and of no legal force and effect. When a court failed to observe safeguards, it amounts to a denial of due process of law. Court is deprived of juris. Administrative clerks masquerading as judges cannot do anything judicial, like issue orders, convictions, or judgments. Ministerial officers. Anyways, ministerial officers are incompetent to receive grants of judicial power from the legislature. Their action attempting to exercise such powers are necessarily nullities. Where there is no jurisdiction, there's no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Saya. The plaintiffs have been using their corporations, State of New Jersey, Inc., County of Cape May, Inc., City of Ocean City, Inc., to exercise the Commerce Clause, Article 1, Section 8, Clause 3, and this is National Mutual Insurance Company, the Tidewater Transfer Company. We therefore decline to overrule the opinion of Chief Justice Marshall. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power, nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. With your plenary dictatorship jurisdiction, plenary, they're talking about plenary power, right? Through their plenary power nationally. Plenary jurisdiction, the court's full and absolute power with the subject matter and the parties in the case. Plenary is full, complete, entire. Plenary is full, complete in the courts of admiralty and English ecclesiastical courts. Causes or suits in respect of the different course of proceedings in each term plenary or summary. Plenary are full and formal. Suits are those in which the proceedings must be full and formal. The term summary is applied to those causes where the proceedings are more succinct and less formal. It's a kangaroo court. Plenary is a plenary power, is a plenary authority's complete and absolute power to take action on a particular issue with no limitations. And that's Wikipedia, which is not a very good source, but this is all in Legal Information Institute, which is Cornell Law School, which is a good source. Plenary power is complete power of a particular area with no limitations. The term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress has granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. And bring the District of Columbia outside not exceeding 10 miles square in violation of Article 1, Section 8, Clause 17. Matter of fact, I should italicize this. In violation of their oath or affirmation of support to support the supreme law of the land under Article 6, Clause 2, and all judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And the plaintiffs may not use a delegated power to attack one of we the people. This is all subjects over the sovereign power of a state extends are objects of taxation, but those over which it does not extend are upon the soundest principles exempt from taxation. This proposition may almost be pronounced self-evident. The sovereignty of a state extends to everything which exists by its own authorities or introduced by its permission. But does it exist to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws are made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. Sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people override their will as declared in the Constitution. Actually, I need to change that font. There we go. The state of New Jersey bar members and their inferior legislative maritime court failed to be a trial by jury and absolutely failed to have anything to do with common law in violation of 1 Stat 73 and 36 Stat 1087 Judicial Code. It's an administrative hearing that failed to have an Article 3 judge, but was an executive branch administrator working for the legislature, which means any ruling or decision was a bill of pains and penalties, which is similar to a bill of attainder, because the inferior legislative court are an extension to the legislature, and there's no Article 3 judge present. Therefore, it's non-judicial legislative act targeted at the respondent, the respondent in error in this case. A bill of attainder means a legislative act, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. A bill of attainder is a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution. Bill of pains and penalties, the legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. Bills of pains and penalties are included in the U.S. Constitution's ban on bills of attainder, Article 1, Section 9, and Article 10, Clause 1, I think. Yeah, Article 10, Clause 1. Article 1, Section 10, Clause 1. Preamble posterity. The respondent in error has ancestors who owned land in Pennsylvania during the War of Independence and also volunteered to serve on the militia. Therefore, the respondent in error is posterity as found in the preamble. He is entitled to right of blood, and no civil law can destroy right of blood because all the laws of Congress and all the laws of New Jersey are civil laws. And this court, as well as all the plaintiffs, are operating under power which is derived from the respondent in error as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. Therefore, it's impossible for the respondent in error to give any of these plaintiffs or their bar member handlers or this court any authority over the respondent in error. And John Marshall, Chief Judge of the Legislative Inferior Court of the United States, agreed and said it's impossible for the respondent in error as one of we the people to confer a sovereignty which will extend over him. And that's McCullough versus Maryland again. And the respondent in error is exempt from these plaintiffs because and from all of the claims of their bar members, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And the respondent in error requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary notwithstanding, Article 6, Clause 2. And we the people fail to be 14th Amendment U.S. citizens because the 14th Amendment U.S. citizen failed to exist when the Constitution was written. All of which is evidenced in the affidavit of citizenship, a true copy of which is attached here to, and the appendix at pages 1 through 24. And I'm not sure if he's got an affidavit of citizenship. I need to talk to him about that. There's nothing this court can do to affect the respondent in error. Let's see, what page are we at? 14, okay. State citizens are the only ones living under free government. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. The sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people, and from whom the government emanated, and they may change it at their discretion. Sovereignty then in this country abides with the constituency and not with the agent, and this remark is true both in reference to the federal and state government. The plaintiffs in this case have repeatedly called the respondent in error a sovereign citizen, and it is true as evidenced by the resolution of Congress, because we have a Republican form of government. There we are all sovereign citizens, as evidenced in House Joint Resolution 183, dated May 3rd, 1940, at 54 Stat 178, where it says in the preamble, whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. The plaintiffs and their bar members are required to know that the Supreme Court of the United States has ruled that everyone and everything not privileged is sovereign, but the plaintiffs have called the respondent in error a sovereign citizen like it's some sort of a bad thing, which is an attack against the republic itself. And the plaintiffs have repeatedly issued letters of marque and reprisal and have taken reprisals against the respondent in error in support of their targetedjustice.com website to show a long train of abuses and usurpations pursuing invariably the same object. Events is designed to reduce them under absolute despotism, which is an attack against the republic itself, which is why the respondent in error is so sad and disappointed, because it looks like the judge is giving aid and comfort to the enemy in a time of war, or is mistaken. The original Constitution of the United States, dated September 17th, 1787, has never been declared void and is the oldest written Constitution still in effect today. Now, some of this stuff a lot of this stuff here is stuff that we've talked about in other documents, and this is stuff we're adding into this one. I don't know, do you guys want to go through all of this? We've talked about it before, or we could skip down to. So we're going through this stuff about the fact that, and the Northwest Ordinance, and actually we cover that up top too. Maybe we should thin it down a little bit. Legislative statutory law, maritime code, and it's talking about common law. There we go. We'll get to the jurisdictional issue. Respondent error has been challenging jurisdiction at every step of this proceeding. Actually, I've been tweaking it here. Respondent error has been challenging every step of this proceeding, and this has had the effect of negating the presumption that the court had jurisdiction in this matter. Jurisdiction can be challenged at any time, and jurisdiction was challenged cannot be assumed and must be decided. So there's court cases to say that a court is not capable of deciding its own jurisdiction. So really what you have to do is get it into the Court of Appeals. Anyways, because the court can't decide its own jurisdiction.
Technically, they weren't supposed to move forward, and the prosecuting attorney was supposed to take it to a higher court. Once you challenge jurisdiction, that judge is supposed to be unbiased and is supposed to kick it back to the prosecuting attorney and discharge the matter.
I agree, but they're not. They want to sell you into slavery is what they do.
Then he's practicing law from the bench in his private capacity.
I agree. But you got to win your case before you can sue him. So, anyways, jurisdiction cannot be waived.
Is Nelson at these meetings?
Sorry?
Does Nelson attend these meetings so that we might get some more insight into this, or?
He'll be on the one on Wednesday. He's right now somewhere else. He's doing something else.
Oh, okay.
So I asked him if he wanted to come on tonight, and he said no. So that's fine. He's somewhere else. He's actually visiting here from New Jersey right now, but eventually he's going to go back to New Jersey sometime between now and April when I go there. He comes down here, in the wintertime because there's nothing for him to do up there anyways. And because the tourist season's when it's really busy, and so he's busy up there, and that's like from May till October. Actually that's why we did our private information share in April, because once May hits, it starts getting busy, and so they're letting us stay there for free, and hold our Northeast private information share, and because normally they rent those houses out for I think it's like $1,300 a night, and people or groups rent the whole house out, and like in the summertime, I guess the place is busy all the time, and they make pretty good money, obviously, doing that.
Yeah, Michelle's been there. She said she's told us about it, and it sounds like a nice place to hang out.
Yeah, well, it'd be nice if you guys could make it, but whatever. Anyways, jurisdiction cannot be waived, neither can it be stipulated to. Subject matter jurisdiction cannot be conferred by judicial admission. Because Andrea herself filed a motion to modify, alleging in pertinent part this court has continuing exclusive jurisdiction of this suit, it could be argued that she made a judicial admission that the trial court had subject matter jurisdiction, or is stopped to deny the court's jurisdiction. However, subject matter jurisdiction cannot be conferred by agreement, nor can it be conferred by estoppel. If subject matter jurisdiction cannot be conferred by agreement or estoppel, then it cannot be conferred by judicial admission. Once the respondent in error challenges to the subject matter jurisdiction of this court by the above respondent in error's challenges to the subject matter jurisdiction of this court. On the filing of a complaint, jurisdiction presumed. However, once jurisdiction is challenged, the presumption of regularity is lost and the jurisdiction must be proven before the court can reach the merits of the case or take one step further. Whether a pleader has alleged facts that affirmatively demonstrate a trial court's subject matter jurisdiction is a question of law reviewed de novo. Likewise, whether undisputed evidence of jurisdictional facts establishes a trial court's jurisdiction is also a question of law. Whether a court has subject matter jurisdiction is a question of law. If whether a pleader has alleged facts that affirmatively demonstrate a trial court's subject matter jurisdiction is a question of law reviewed by de novo. Likewise, whether undisputed evidence of jurisdictional facts establishes a trial court's jurisdiction is also a question of law. Once challenged, jurisdiction cannot be assumed, it must be proved to exist. There is no discretion to ignore that lack of jurisdiction. Where jurisdiction is contested, the burden of establishing it rests upon the plaintiff. The burden of proving jurisdiction rests upon the party asserting it. Court must prove on the record all jurisdictional facts related to jurisdiction asserted. Jurisdiction is a matter between the defendant and the court. If the court has made a demand for the defendant to stand and answer a charge, and therefore it is the court that must prove its authority to rule and make said demands. Once jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action. The court cannot reach any of the merits of the case before jurisdiction is proven. Determining the existence of a subject matter jurisdiction is a threshold inquiry, and a claim is properly dismissed for lack of subject matter jurisdiction under Rule 12b-1 when the district court lacks the statutory or constitutional power to adjudicate it. Respondent in error reminds this court that the matter of jurisdiction is not a matter within the discretion of the court. Subject matter jurisdiction is the essential party of the authority of a court to decide a case, and it is never to be presumed and cannot be waived. The reviewing court determines whether subject matter jurisdiction exists as a question of law, subject to de novo review. There is no discretion to ignore the lack of jurisdiction. The burden shifts to the court to prove jurisdiction. I'm making little adjustments to this thing as I go along, as you can probably see. The principles of waiver, consent, and estoppel do not apply to jurisdictional issues. The actions of the litigants cannot vest a court with jurisdiction above the limitations provided by the Constitution and Congress. The Supreme Court noted, a court generally may not rule on the merits of a case without first determining that it has jurisdiction over the category of claim in a suit, subject matter jurisdiction. Declining to address jurisdiction and holding that the district court have authority to dismiss action on forum non-convenience ground before considering the merits. Rejecting the doctrine of hypothetical jurisdiction that would allow a court to rule on issues of law before adjudicating jurisdiction. Plaintiffs have failed to prove jurisdiction. Or even answer the challenge of jurisdiction, another denial of due process. If the plaintiffs fail to provide jurisdiction, the court is required to presume the proof fails to exist. And so he was convicted. So the judgment of conviction is absolutely void and a nullity. A void judgment is one which from its inception was a complete nullity and without legal effect. A void judgment is one which has no legal force or effect whatever. It's an absolute nullity. Its invalidity may be asserted by any person whose rights are affected at any time and at any
End
place.
of the earth, I just messaged you. I'm sorry. I apologize, guys. My last name Thompson.
Yeah, we have a chat going on here right now.
What are you guys discussing?
Well, maybe you should be quiet and find out.
Yeah,
Go
I just
ahead,
muted
Glenn.
him.
I have no idea what that was about.
I muted him, so there won't be any more. A void judgment is one which has no legal force or effect whatever. Its absolute nullity, its invalidity may be asserted by any person whose rights are affected at any time and at any place. It need not be attacked directly, but may be attacked collaterally whenever and wherever it's interposed. A void judgment, insofar as it purports to be a pronouncement of a court, is an absolute nullity. A void order may be attacked either directly or collaterally at any time. A void judgment is one from which, from its inception, is and forever continues to be an absolute nullity, without legal efficacy, absolutely null, and without legal efficacy and effectual to bind the parties or to support a right, of no legal force or effect whatever, is incapable of enforcement in any matter to any degree. A thing void in the beginning does not become valid by lapse of time. Time cannot render valid an act void in its origin. Things valid from the beginning cannot be made valid by subsequent acts. See, this is what I'm going to put in my nastygram when I sent them that notice of contempt. Things invalid from the beginning cannot be made valid by subsequent act. Once a fraud, always a fraud. What is otherwise good and just, if sought by force or fraud, becomes bad and unjust. Out of fraud, no action arises. It is a fraud to conceal a fraud. And fraud is inexcusable and unpardonable, and any fraud amounts to injustice. And the judgment is brutum fulmen. I put this in a federal case when I told the judge I wanted it removed into state court, and I told him it's everything he does is brutum fulmen. Anyways, brutum fulmen, an empty noise, an empty threat, a judgment void upon its face, which is legal effect, no judgment at all, and that's what I'm going to put in this one too. And by which no rights are divested, and from which none can be obtained. It neither binds nor bars anyone. Black's Law Dictionary, 4th edition. Wherefore, premises considered, respondent error moves the court to dismiss this case with prejudice and vacate all previous judgments in order. And that's it. So the rest of it is the certificate of service. So that's the
Any other exhibit?
Total of that's 27 pages. We got to look at the rules. We might have to shrink it down, but you know, that's it basically. So that's the coram nobis that we're planning on filing.
Might I make a suggestion? If you want, you could use exponent numbers in there and strip all or most of those court cases and put them on as an attachment.
Well, you know, go ahead, knock yourself out. I know what I'm doing, and you can do it your way if you want. I wouldn't do that, but go ahead and knock yourself out.
I was just suggesting.
I mean, you can make it as difficult as you want. I mean, really, I mean, they say in the federal rules, if there's local rules that they say that if your brief is less than 10 pages, then I should say if it's more than 10 pages, you have to put a table of contents and a table of authorities. And so, yeah, if you want to do that shit, I'd rather not. Quite frankly, it's a lot of work. And so there's nothing in the rules to say anything about having to do that. And so I ain't going to do anything that's not required by the rules.
Okay, I'm not sure if we're communicating. You know what I mean by exponent numbers, right?
It really doesn't
That
matter. I'm not gonna. I put the sites there. They can look them up if they want. He is anal about these sites. He goes and looks them all up and makes sure that it says what it says. And there's some of these sites he doesn't like, so he won't use them. And I don't have a problem using them. There's a lot of sites that are summaries of a case, like that. Um, um, that case that says all the government can only interface with corporations. Doan's administrators.
Yeah,
And people don't like that, but it happens to be a summary of about 5 pages of that case. And people don't want to use it. Go ahead, sabotage yourself. I don't give a shit. It's not my problem. If you're too stupid to use it, then that's your problem, not mine. Anyways,
that's not what I'm saying. What I'm saying is you can reference Doan's the court case, put an exponent number on there, take the case the opine that you're trying to put into the case, you know, and I'm not saying take them all out. I'm just saying that you could actually reference them by exponent numbers, and then put them on as a listing of attachment on the back side of the paper, thereby reducing the amount of papers that you have, but still having the court cases attached.
To thin it down. Yeah, okay, well, that's an interesting thought if I wanted to thin it down. But at this point, I like having them there. And until I find what the rules are, if I need to thin it down, quite frankly, what I'll probably do is I'll probably just, that's a size 14 font right now. So I can make it a size 12 font easily. I've even done them with a size 11 font, and that'll shrink it down quite a bit. So if there's something in the rules that we find that it needs to be shorter, that'll be the first thing I'll do is I'll change the fonts. I'll shrink it down. There's a lot of places I can take out spaces, and that's what I do, because I want to make it easy for them. I don't want them having any excuse to ignore it. Anyways,
well, another thing you might think about too is if you're being redundant with regards to a case, if you put the opine in first, just reference the case because you've already put the opine in if you're going to use it further into the document, and that would help thin it too. See what I'm saying? In other words, you gave the opine the first time in the document, then further down you want to use it, just put the case instead of the whole opine.
Yeah,
you've already put it in.
I know.
I was asking earlier about what they had done to him, what they were charging him with, because I was trying to figure out if Bruin might be applicable.
It doesn't matter. Okay, he was convicted, and it's all a charade. It's an administrative court. That's all that matters, and they don't have authority. That's all that matters. It doesn't matter. He could have whatever. It doesn't matter, and it's nobody's business what he's convicted of.
I'm not worried about what he did. What I was more worried about is what Bruin talks about with regards to your rights. And I didn't know if he was in another state when he had done this, and that he was utilizing whatever he was doing was a right that he was exercising, and that they're violating that right. And Bruin talks about you can't diminish a right by traveling across a state line.
Yeah, it's
not.
It's nothing to do with that.
Case. Okay, all right. That's just where my train of thought was going.
Anyways, I'm going to look over YouTube here and see if they have any questions.
Are you going to put this document on the channel?
Doan's Administrators is spelled DOANS, Administrators. It's a 1793 case. If I do upload this document to the group, I'll probably delete the header and the footer stuff, and then you'll have the case law, all of the arguments. But and each state is going to have different requirements. You got to look in your local states for the what the requirements are. But you know, to sanitize it for him, because we haven't even filed this yet, and so it's, if it was a government, if it was filed, then you know I'd probably just upload the whole thing. But it's nobody's business who he is at this point.
Well, I don't want to put you to any extra work. The only reason I generally am interested in your documents is because I'm always trying to collect ammunition, if you were, court cases, and I got most of the ones that you had in there, but you know, you always seem to have extras, and you know, I like building my library.
Well, there's nothing wrong with that, and I can upload it, but I'm going to sanitize it first if I do.
Well, I can actually, I don't want to put you to extra work. I can wait until you do file it, and it becomes a matter of public record.
If you remind me, you know, I'll be happy to provide it then, I suppose.
I caught the video that y'all did on Wednesday, and I was listening to you and Nelson talking, and I'd actually emailed you today, and you sent me the documents. Am I correct in assuming that as y'all go further into the rest of these organic laws, that as you go through the documents, the other ones that he got from the library are going to be made available?
Well, didn't you send me an email today asking me for the Word files, the best one, the text?
Yes, I got two documents. I got the Northwest Ordinance. I didn't get the Declaration of Independence or
There's
the
all of them,
Constitution.
all of the Word files. I sent you all of the Word files, so you need to look, because I sent you all the Word files. I sent you what you asked for, but I sent you all the Word files. That's what you wanted.
Yeah, I got two Word files.
No, there should be more than two.
Okay, well, that's what I'm saying. I did not get the Declaration of Independence or the Constitution. I can email you again and ask for those. Somehow they didn't come through. I just didn't know if that was because y'all have
right here. I have your email right here, and I'm looking at 6 documents filed. So you need to look at your thing. You're not seeing it. I don't know what your problem is on your end, but I'm looking at the email I sent, and there's 6 documents attached. So either, I don't know, maybe you got vexed or something. I don't know. But I sent you, the email I sent you has 6 documents attached.
I'll take a look and see if I've missed something.
Anyways, I'm just looking on the YouTube channel and seeing that there's a lot of comments. But I'm not seeing any real questions.
Hey, Glenn, can I just say, I really love your work. It's been great.
Well, I appreciate it. It's a networking thing. I don't know everything, and so you know, it's a networking thing. And you know, when I was 16 years old, I got a patriarchal blessing, and it said, "Unto whom much is given, much is expected." So I feel like I have to do this so that I'm held blameless on Judgment Day. And if there's anything I've learned, it's warfare. Okay, you have to understand that it's warfare, and so the best defense is a good offense.
That's why they say you have to be belligerent, right?
Yep.
Well, I joined the class a little bit late here, or the meeting here a little bit late, and I always love seeing your work, but I would love to see this document whenever it gets published. It'd be great. or whenever it gets shared will be wonderful.
Well, we're not finished with it right now, and then plus it has
Yeah,
been
I
filed.
heard that. Sorry. Yeah, I heard that. I've been here for 10 minutes.
I'm typing stuff in. Um, And so there's people on YouTube that are asking questions. So they wanted to know Doan's administrators, and then I'm telling them that this is We Are Law on Telegram. So if they want to, they have to get on Telegram and join the group on Telegram. The way it got wrong is we the people were asleep at the wheel. Is really it started with the Civil War, and really that's where it really started. So it's been going on for 150 years. And you see what Trump is doing. I think he's trying to restore the republic. I think that it's going to get restored. Well, you know, I'm not sure. What I'm thinking is there's going to be a North American Union, and that will be a republic, and that will last. You know, that'll last for a long time. But so I guess we'll see what happens. But I think that yeah, it's you know, it's what happens when you want to be free. You have somebody, the tyrants, that want to take away your freedom, and they lay awake at night trying to do it. And so we're basically in an insurgency right now, a communist insurgency, and they're trying to overthrow our government and enslave us. And fortunately, there's a bunch of us that are awake to this stuff, and some military, some wonderful, wonderful military generals that launched a counterinsurgency, and that's what Trump is a part of, is a counterinsurgency, and so I really think that that's what's happening. General Flynn, that guy is wonderful, and so I just can't say enough about all those guys. You know, they understand, and that's what I guess. Trump just removed 5,000 deep staters out of the Pentagon. Woohoo! Go Trump, go! And so you know,
maybe they ought to send some of these generals around to round up some of these family court judges.
Well, eventually it might come to that, but again, it's got to come from we the people. We the people need to start exposing it and doing our best to expose this stuff. That's why I'm gonna, when I file this notice of contempt, I'm gonna put a certificate of service at the very end, and I'm gonna send a copy to Trump, and everybody else is gonna know it, and to Cash Patel. And so we'll see what happens. You know, that's all I can say. But you know, I can tell you this for a fact. When in Trump's first term, he had Jeff Sessions as the Attorney General, and I filed a 200-page criminal complaint against Jeff Sessions, and he came out and started bad-mouthing Jeff Sessions. And we all know what happened with Jeff Sessions. He got removed. And and then I filed a criminal complaint against Kirsten Nielsen, and he came out and started bad-mouthing Kirsten Nielsen, and ultimately he removed her ass. And so I'm telling you, I think he reads my stuff. Anyways, I have no proof, but I'm telling you, when I send that stuff to him, I think he gets it. I think he reads it, and so I think he understands what's going on. And so, by all means, I can't imagine how many people are sending him stuff, and so maybe he's got teams of people that read that stuff and give him a synopsis or something like that. I don't know, but you know, I sent him my book, and he sent me a letter back saying thank you for the thoughtful gift. And so, anyways. Yep. Anyways, so anybody have anything else? I'm looking at the chat on YouTube, and I don't see anybody really need people do need to wake up. You got that right. And people are big time. Anybody got anything else? I think we might as well wrap it up. It's only been going for about an hour and 20 minutes, but unless we have something else we want to talk about.
I hope Nelson allows you to share that with us, and you'll put it in your room whenever it's good, because there's a lot of good information on there that we could, is key for things. So please share it with us. Mm-hmm.
Run that by me once more, Lori. I'm sorry I didn't get all of that.
Well, once Nelson approves you sharing it out, or you've redacted it, put it in your room for us, please.
I will. Yeah, I'd like to get it finished first to where Nelson's satisfied. And he is anal. I'm telling you, he is anal about these things. There's some court cases he'll look them up, and he checks them, and the capitalization, he goes through it with a fine-tooth comb. And so I'm making a bunch of changes to the one that I got, and I'm going to send it to him after I'm done here. And then he'll look it over, and he'll send it back with some more changes, and we'll talk about some things in there. And I'm telling you, he is really anal about it, more anal than I am, quite frankly.
Wow, that's hard to do. No, I know the school board people don't like him that much in his city, do they? He was showing us that YouTube of the meeting that he went to, and yeah, he's standing up to it. He's awake for sure.
Well, and everybody's got to do their part. A republic is being active citizenry. Everybody's got to be doing it, and it can't be just coming from a few people. It's got to be coming from everybody in their own way. And the more you do it, one of the things that really is a bone of contention of mine is the militia. We should have a militia. In the old days, in colonial days, they had to be armed. And if they came to a public meeting without their arms, they got a fine. And if they came to, they were outside of town more than 2 miles without their arms, they got a fine. And those fines went to support the militia. And so they had their arms, they carried their arms with them. And I really believe that's where it's going to go. It's going to come to that. I've heard that, matter of fact, I'm hearing lately that Comey, the former FBI director, he's going to get indicted. Okay, he knows it's coming. There's some General Flynn videos about that. He says that Comey's going to get it. That's going to be one of the first things that's going to happen is Comey's going to get indicted, and he might as well get outfitted for an orange jumpsuit. He said to go to the big and tall shop. He's a tall guy, I guess, so they're going to sit there and they're going to give them an opportunity. And so there's going to be pardons. Okay. I guarantee you it's about truth and reconciliation. You remember Facebook, Mark Zuckerberg went to visit Trump, and he came out of there and he made a public announcement immediately. He said, we were forced to censor people, and we deeply regret it. And it's going to stop as of now. And so that's his truth and reconciliation. Okay. He gets a free walk now because he admitted his errors and he's repenting. And so they're all going to get that opportunity. At least a lot of them. The ringleaders won't, but a lot of them are. But Comey, they got evidence on him. They got lots of evidence on him. So what they're going to do is they're going to be raking him over the coals and saying, who did you talk to about this? Who else knows? Who else knew? And start building a case. I'm telling you, that's what's going to happen. The shit is hitting the fan right now. And General Flynn put out a video here yesterday, or was it yesterday, the day before? He said within 2 or 3 months, Comey's going to get an indictment. And so, anyways, the shit is hitting the fan.
Well, that orange jumpsuit's going to look awfully damn good on that dude.
No shit. It'll
I
be
hope he
lucky.
has a big trustee sign on the back on his back, showing that he put himself there.
Yeah, I don't know how that's all going to work, but I think it's going to be good to see. That's for sure. People need to see that justice is being done, and people are really pissed about all this shit, and it needs to be put a stop to. And so, absolutely, um, they're we're going to see huge things happening over the. Cliff High said in the next 6 months, he said that it's just going to be absolute chaos, and then in the summer it'll basically level off, and we'll get used to it all. And he said, but the chaos is going to be going through the roof, and so there's going to be people, there's going to be indictments, there's going to be trials, there's and they've gone in Guantanamo Bay. They're going to go to Guantanamo Bay. And so
That's too good for him. I said that. That place
what
is too much good for him.
I agree. There's what's happened is a friend of mine goes to flea markets. He sells cell phone accessories and everything at the flea market, and he said the flea markets are dead because all the illegal aliens, they won't go there. They're scared to death because the rumor is they're going to send the illegal aliens to Guantanamo Bay, so they're leaving on their own. There's a mass exodus of them just leaving because they don't want to go to Guantanamo Bay.
Wouldn't hurt my feelings.
What's that?
Hey, Glenn, it wouldn't hurt my feelings if they did exited on their own. Hey, I checked my email, and I don't know what happened this morning, but everything's there that you sent me.
Yeah,
So,
I know what I said.
I appreciate it.
Okay.
Well, like I said, I was just telling you from my end. All I saw this morning were two.
Okay.
But all the rest of them are there, and I thank you very much for that. Did you catch Cliff High talking about he got assaulted and had to defend himself, and he's basically changing up his mode of operation now. Instead of going places by himself, he's going to be going with people. I don't know if he's being targeted or something, but he had to defend himself physically against some thugs.
He was. I think that's old news, quite frankly. I don't know what video you watched, but he puts out all of his stuff on Substack. Anything new is going to be on Substack, and so that's where I would go, is Cliff High at Substack. Plus, he does sometimes he'll do something on it's not Rumble. Okay, if there's one on Rumble, it's a bootleg video of him that somebody else got and uploaded it to there. So he doesn't do Rumble. He doesn't put his videos on Rumble. He puts his videos, but he does it all on Substack. He's been doing Substack for the last couple of years now, and just exclusively Substack. And so he puts his videos and everything on Substack. So if people are anything, you find anything of his anywhere else, it's not his. Okay. Well, it's probably him, but it's from 6 months or a year or 2 years or 5 years ago or something. You see what I'm saying?
Well, I'm catching them on YouTube, and the videos. I may have been looking at an older one, but most of the videos that I catch are a day old, 3 days old, that kind of thing. Were you thinking maybe BitChute?
BitChute, yeah, that's it. If you find him on YouTube, he hasn't uploaded to YouTube for a long time, and so again, there's somebody there bootlegged, and what he does is he'll have the date on a whiteboard behind him when he's doing it, because he wants people to see the date. Because just because it was uploaded yesterday doesn't mean the video was made yesterday, and so that's why I don't listen to any of his stuff from any other source. I want the latest and greatest stuff. I've been getting his stuff for a long time, and some of his stuff is I still have trouble getting my head around it. I don't necessarily say it's not true. I just don't necessarily believe everything he says. But he's got a lot of. He's a brilliant guy, and I really like what he does. Some of it, I kind of just put it in the back of my mind. But he's got some great stuff.
Yeah, I've been listening to him for years off and on. I'm unfamiliar with Substack.
I'll
look
talk
that
about
up.
it later. They're a social media group where you can combine all your media. It's not that great, so let's not waste Glenn's time with social media stuff. So does anybody have any other questions for Glenn?
I do, regarding habeas corpus. So if this doesn't work out with regards to this court process and the writ of coram nobis, I have been hearing, since they believe we're under martial law from the Civil War, that you might be able to get them into a UCMJ court with a habeas corpus. Just a thought.
That might be possible. It depends on which state you're in. Okay, if you're actually, you should be able to do it in just about any state. But it's a little bit more difficult to argue, like if you're in New Jersey, because New Jersey was never at war, although the martial law was imposed in New Jersey as well as everywhere else. Matter of fact, there's the ex parte Milligan case where that guy was in Ohio, which was not one of the southern states, and all he was doing was speaking out against Lincoln, and they arrested him and charged him and put him on trial and sentenced him to death by hanging, and he sent a handwritten habeas corpus to the Supreme Court, and so ex parte Milligan is the answer. And I think ex parte Milligan is why in the rules of the Supreme Court, it says, Rule 45, it says that all mandates of the Supreme Court come under authority of the President of the United States, which means there's really no separation of power. I think Lincoln was pissed when the Supreme Court issued that ruling. So anyways, wah. I think that that's my opinion. So, I guess we'll see. I agree. A habeas corpus, that was another thing we were thinking about doing with this guy. We wanted to open up the case, the original case, and overturn it, because then if we do that, then we can sue him. If you do a habeas corpus and you win on a habeas corpus, you can't sue him. And so he wants to sue him. And so, that's one reason we're doing this, because we want to reopen the case, so then we can appeal it and get it overturned, or get it overturned here, because then we can sue him, and that's where he wants to go with it.
I was unaware of that habeas wouldn't allow you to sue them. I mean, a wrongdoer is a wrongdoer.
Yeah, if you can convene a common law court, you could probably bring it to a common law court, but the de facto courts won't allow you can't sue them. There was actually a friend of mine who filed a mandamus into the federal courts here in Texas. And O'Connor, he's the same judge I got that I'm going to send a nastygram to. He went and responded to it, and he said that reading this liberally, he said that it looks like, he says that, first of all, the federal courts don't do mandamuses anymore. And he said, but reading it real liberally, this guy was on bond, and he was out free, but he was on bond from a criminal proceeding. And he said, reading this thing liberally, it looks like he might be asking for a habeas corpus. And so he said, and he told him which form to file too. And so he's got to do it by the 3rd or the 5th of April or March. So I've been after these guys to do the habeas corpus, and we did a habeas corpus, but we didn't put the case number, and so that's what we needed to do. We should have put the case number that O'Connor opened, and file it and see what happens. Who knows? We'll see what happens. That's all I can say. But we haven't done it, and we need to do that because he's in jail now over other stuff. But at least we can make one of his issues go away. I guess we'll see. He's got a bunch of issues.
You're not referring to Nelson?
No, this is someone else we're helping.
Okay, so how is everybody done with that? Because I wanted to ask Glenn about how his brother's making out up here in communist Canada.
I got to contact him. I think that we need to try and do he's got a show trial coming up, and I think we're going to do a challenge to jurisdiction. Probably ought to do a couple of them. We've already done one or two. We probably ought to do. I'm thinking about maybe a. We need to appeal an order. That's what we need to do. He's got a case coming up in May. He's got a trial coming up in May. We need to appeal the order and see what happens. Canada's different. That's the problem. Is it takes a bunch of research. I'm going to have to do the research because he's got a grade 8 education, so he doesn't know anything about how to do it or where to start. And so I'm going to have to do it, and I've just been busy. So anyways, that's where it's at. He's got a trial coming up in May.
So you're going for a full dismissal, of course.
Sorry?
He's going for a full dismissal.
Well, if we do we got to appeal an order. We got to set it up to an appeal in an order. That's probably the best thing to do. It's a traffic matter, but they keep harassing him. He is a bit stupid, in my opinion, and he think the problem would just go away, and it didn't. And they assaulted him again, and so now he knows that he's got to deal with the matter. And this is in Alberta, in communist Alberta.
Yeah, Queen's Bench.
Yeah, the bitch.
Queen's Bench, you said it first, but that's what I was going to say first. So
isn't that King's Bench?
Thank you for saying it first. Unreal.
Isn't that King's Bench now?
Well, I don't know. Is he really a king? Come on. King of what?
Yeah, no joke.
Don't get me going, but no. So yeah, I don't want to keep you any longer, but I wish your brother and Nelson both all the best in all of this and all of his cases. Just keep on. We've been hearing lots of success stories. This week we heard a couple, and then 5,000 dumbbells gone out of the penguin Pentagon, so that should help dry up the swamping.
Well, it's certainly got to start somewhere, and it's in progress. And so we're having some good things happen in D.C. That's for sure. And thanks to Trump, and thanks to all those generals that have launched that counterinsurgency. And I'm sure they're still doing stuff behind the scenes.
Yeah, stuff we don't know about yet, but it's in.
Hey, Glenn, you ever talk to Pete? Sorry, I'm sorry. I know you thought you were done, honey. Hey, Glenn, you ever talk to Pete?
Who?
Pete. Our contract lawyer out of Austin.
Yeah, no, I haven't talked to him lately.
Well, how do I reach him? What's his last name again?
Well, I could tell you offline if you want to email me or something. I would suggest.
I'll just DM you.
Sorry?
I just give you a DM.
A DM.
Yeah, direct message here.
Well, that'll be on. Everybody will see it.
No, that's on your.
It'll be a private DM.
Yeah.
Okay.
That's directly to you, or if you want Batman, I can give you Glenn's email.
Yeah, my email is better. Just tell me if you email me that who you are. It's Batman. I know who Batman is.
Right on. Yeah, I'm gonna throw you a DM real quick right here. Dum, 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 dum.
Hey, Glenn,
So,
I'd like to thank you again for the documents you sent me, and if you would, extend my thanks to Nelson too, because I know he paid for them, and he's made them available to everybody. So that was, some effort and expense on his part, and it's appreciated.
Well, those are the Word files. Those aren't the certified documents. You didn't say you wanted the certified documents. I can send those if you want to.
Oh, yeah, yeah, okay, I thought that's what I was wondering about the Word document, but
Well, you
yeah.
said you wanted the Word files, so I sent you the Word
Well,
files, the best ones.
I was,
I
I,
can send the I'll upload them to the group, and then everybody will have them.
okay. Yeah, he's right. I mean, those documents have been tampered with. Anything you get off the internet, I'm suspicious of.
Well, you can't, you know, the ones that I'm going to send you are hard to read. And what he did is he went through them and just looked at the capitalization and stuff like that. But they're hard to read. They're PDFs. He sent them. They sent him paper copies, and so these are PDFs of those paper copies. And so they're PDFs, and then it was scanned up, right?
Yeah, that they would have done that on with pen and ink on vellum originally. So, but I'm kind of used to looking at stuff like that, looking at land patents and such. So, yeah, if you can send me the PDFs, that'd be wonderful. But you can post them on this channel as well.
I'll upload them to the channel.
Okay. Thank you.
Thank you. Appreciate it, Glenn.
Yeah, no problem. Anyways, if that's it, then we'll see you next week, same time, same place, same channel.
I guess so. I have.
Same bad time, same bad channel. Very good, Glenn. That's funny.
There you go. Same bad time, same bad channel.
No problem. No, I had a bad lawyer joke, but we've heard enough about liars tonight, so I'll try and critique it so it's really good for next week.
I'm uploading these documents, so if you want to tell us a lawyer joke, I'll be willing to listen.
You mean a liar joke?
A liar joke, yeah, that's right.
Okay, but I only know half of it, so it's gonna really suck.
Half of it? Half a joke? I've never heard of such a thing.
Okay, well, I'll tell you the half now, and then next week I'll get the other half down pat. But the first half is a liar walks into a bar. Guess what the bartender says to him?
Who knows?
There's no ambulances coming here.
Okay, I'm not sure I get that.
Well, the next part you will.
Ambulance chaser.
Oh, ambulance chaser, right?
So what? That was half the joke. So this is going to be a serial joke.
The other half revolves around pinpointing exactly what kind of liar it was.
Okay, well, so we'll get part 2 next week.
I told you I'm a bad joke teller.
Well, that was funny.
This is how they do it in Canada?
Oh.
Is this how y'all do it in Canada? Just asking. Is this how y'all do it in Canada?
No,
Just asking.
I've defected. Now I'm American, so that's how we do it in America.
In the UK, have
Come
you
on,
arrived?
you guys are all American. Cough up one. Come on.
Have you arrived?
No, I've only got my paperwork.
Oh, well,
I got my defection paperwork from my minister. who's also defecting. So, or no, one of my ministers. So, yeah. It's a 51st state now.
Well,
Yeah,
let's
you
say
won't have to defect.
I've heard that Canada is, well, it won't be the 51st, but it'll be part of the North American Union. But first of all, they got to balkanize the U.S. first.
What does that mean? Vulcanize.
Balkanize. It's going to break up.
I've heard that they wanted to make the states individual.
Well, they are under the
Like all
Republic.
federal anyway.
They are under the Republic. We're not. It's all we have. All we have is a bunch of corporation that's got corporate governors involved. The states are already independent.
Okay,
Self-governing republic.
I guess we could debate that all night, huh?
Declaration of Independence, Bill of Rights.
The Republican form of government hasn't gone away. It just went dormant. And there are people working on getting it back online.
Yeah, then they'll probably then they go ahead and be re-sign the ICCPR. That way, your articles 1 through 19 won't be or will be self-executing, because you will have a right to self-determination, your free will, your free speech, your free activities, the self-determinating republic, not this corporate bullshit.
Yeah, well, you didn't lose those rights, and those are God-given.
That's right. That's right. As long as you're able to stand on your square, you know who you are.
That's right.
Stop saying here.
Unalienable. So, Glenn,
I like
Cannot be transferred, cannot be sold, cannot be conveyed, cannot be moved. They're sticky balls. They're all over you.
I like unalienable. Can't put a lien on my rights.
You can never waive a right. You just can't waive a right.
Well,
not in that sense and not in those words, but you can contract, and for them to have to be applicable, but you can't waive a right. It's impossible.
Yeah, well, it's like slavery has been abolished, but voluntary slavery is not.
So I've uploaded the certified documents. If you guys want them, they're uploaded to my group on Weir Law on the Telegram, and so you can get them there. Okay, so
thank you.
I'm going to check out here, and thanks everybody for watching, and we'll see you next week, same time, same place, same channel.
Okay, I'll talk to you during the week. Thank you very much, Glenn. It has been very insightful. Give my best to Nelson and your brother.
I will.
I'm glad you're still kicking, Glenn.
All right, yeah, still kicking. That's for sure. Yep. Take
Yeah,
care.
Every day
I left my number. I left my number in the DM. Have Pete get a hold of me.
Okay.
Thanks, buddy.
Okay. See ya.
Bye.